Right, so I think we are going to get started. Good morning, everyone, or depending on where in the world you're joining us from, a very good day to you. And this includes our friends who are watching on YouTube as well. It gives us a great pleasure to welcome you to FPF APAC's LinkedIn Live, and this is our first, in fact, for 2025. Thank you so much for joining us today. We're really pleased to have you here because today we'll be doing something very special, which is to launch FPF APAC's latest issue brief. So I know everyone will be very interested to learn more about what this issue brief is, but in case you're joining a FPF LinkedIn Live for the first time, let me just share briefly what FPF is all about. So the Future of Privacy Forum is a global non-profit organization focused on fostering principled and pragmatic data protection practices in support of emerging technologies. We have offices in Washington, D.C., Brussels, Singapore, Tel Aviv, as well as a presence in New Delhi and Nairobi. We also aim to bring together all stakeholders, governments, industry, academia, technologists, civil society, to foster conversations that develop trust in the data protection ecosystem. So our flow today and ground rules today are actually very simple. I will be officially kicking off the launch of our issue brief, and we will have then our APAC Policy Associate, Sakshi Shivhare, share a summary of its contents. We will then be going into a moderated discussion with two excellent and highly respected experts on data protection in the region, Charmian Aw and Darren Chng. And if at any point in time you have a question, please feel free to put your questions up on LinkedIn anytime. We will be tracking this, so your question could very well be raised in this platform. I'm following all the podcasts that we've been watching in Singapore recently. Apparently, this is the modus operandi to get your questions asked live, so we will be doing that as well. So right now, I'm very happy to announce the official launch of FPF APAC's newest issue brief, which is titled Keeping Up with Consent in Data Protection Frameworks, a comprehensive update for APAC. So yay, it's launched. Thank you, everyone. Thank you. So in 2022, to give you some context, FPF and the Asian Business Law Institute published a series of reports examining consent regimes and legal bases for processing personal data across 14 different jurisdictions in the region. And since then, because of the fast evolving data protection landscape in the Asia Pacific, we thought it would be timely to provide an updated view of evolving consent requirements and alternative legal bases for data processing across several APAC jurisdictions like India, Vietnam, Indonesia, South Korea, and Malaysia, just to name a few. The issue brief also explores how the rise of AI is impacting shifts in lawmaking and policymaking across the region when it comes to lawful grounds for processing personal data. So we're very happy to launch this. And of course, if you want to take a look at the issue brief, it's live. Just take a look at the link that is in the LinkedIn comments chat, the link over there. If not, you can always go to our FPF website, and under one of the tabs under content, you will be able to find the issue brief as well. So wherever you are, please join me in congratulating everyone in FPF that helped to put this issue brief together, including our APAC team, our comms team, as well as our global privacy team that's led by Dr. Gabriela Zanfer Fortuna. I also know right now our comms team in the US, based in Washington, is helping us manage this call as we speak. And it's very late for them. It's 10:03 p.m. EST right now. So a big thank you to them for their tireless efforts and for staying up to stay together with us. Now, I'm sure many of you are already starting to dive into the report. So allow me to introduce my colleague, Sakshi, Policy Associate for FPF's APAC office, to join us to share a quick overview for the issue brief. So Sakshi, over to you.
Hi, everyone. Thanks so much for joining us today. Thank you, George, for that introduction. My name is Sakshi. I am Policy Associate at FPF APAC and the author of the issue brief we are here to discuss. I really am honored to have had the opportunity to work on this brief. And on behalf of the entire FPF APAC team, I hope you will find it valuable. If you work in privacy in this region, you know how challenging it is to stay on top of all the regulatory developments. This report is meant to make that easier, to give you a clear, up-to-date map of how consent and other legal bases are evolving in the region. We are in a moment where the privacy landscape is changing rapidly. Across the region, Jurisdictions are racing to regulate technologies that many of us are still coming to fully understand. In the past couple of years, you've all seen it. AI guidelines, safe use of facial recognition technology, regulations on biometric technologies, and the list keeps growing. And just this year, two major APAC jurisdictions made big moves for direct regulation of AI. South Korea passed its AI Framework Act. Japan's cabinet approved the text of AI bill, which has now been passed by the House of Representatives. So that's also moving swiftly. But amid all this momentum, the issue briefs brings back the conversation to something more foundational, one that underpins everything in data protection. What is the legal basis for processing personal data? As Josh rightly introduced, the issue brief is also a top-up to a year-long project that FPF and Asian Business Law Institute completed in 2022. And this new issue brief builds on that foundation and captures what has changed since then, since 2022. And there has been a lot. The region has undergone a significant transformation. We have moved from fragmented sector specific rules to more comprehensive frameworks. You're probably familiar with these developments. India enacted its Digital Personal Data Protection Act, or the DPDPA, in 2023. Vietnam's Personal Data Protection Decree came into effect in July 2023, and the country is now even moving towards a more comprehensive national data protection law. And Indonesia passed its personal data protection law in 2022. These new legislations are all central to consent, but not limited to it. More and more jurisdictions are recognizing that relying solely on consent can be limiting, especially in a digital world. So we do see alternatives being introduced, like India's DPDPA includes certain legitimate uses, even though they are narrowly scoped. Vietnam's decree outlines circumstances under which personal data may be processed without consent, emphasizing on urgent situations and legal obligations. Indonesia incorporates GDPR-style alternatives like contractual necessity, vital interest, public interest, and legitimate interest. Now, it's worth noting both India's DPDPA and Vietnam's decree do not explicitly include legitimate interest as a legal basis. And in that sense, they are quite aligned with what we see in China and Malaysia. But in contrast, 10 other APAC jurisdictions have adopted more flexible data protection frameworks, one that do recognize legitimate interest or something equivalent to it. So, while the trend is clearly moving towards a broader set of legal bases, there is still a lot of variation across the region, and that's something we really need to keep an eye on. Even more mature jurisdictions continue to evolve. South Korea is a great example. As we know, one of the most significant updates to South Korea's PIPA came in 2023 that lowered the threshold for relying on two alternatives to consent. One, when processing is necessary to perform a contract, and another for situations involving imminent danger to life, safety, or property. These 2023 amendments to South Korea also introduced additional legal basis for cross-border data transfers, something that is incredibly critical for businesses in the region. At the same time, we are seeing efforts to make consent more meaningful and user-friendly. Philippines addressed consent fatigue in its guidelines on consent. South Korea issued guidelines to help the consent process more understandable and accessible to individuals. And India introduced a novel concept of consent managers, which many of you will be watching closely as the DPDP rules roll out. So what we're seeing here is a multi-layered update, not just to legal threshold, but also to supporting guidance that helps organizations apply these rules in practice. There is also a growing focus on sensitive data and protection of children's data. India mandates verifiable parental consent. Vietnam requires age verification from all parties involved in the processing of children's data. South Korea recommends including key information on children's consent in privacy notices and using symbols and infographics for clarity. For sensitive data, Philippines requires that consent must be specific to purpose and prohibits relying on legitimate interest as legal basis for processing. Now, the issue brief is called Keeping Up with Consent, but in all fairness, we cannot keep up any discussion without keeping up with AI. AI is becoming a key driver for rethinking legal basis. Take South Korea's proposed amendment to PIPA. It introduces a new article allowing personal data to be used beyond its original purpose of collection, specifically for AI development. And in Japan, the PPC's package of potential amendments to the Act on Protection of Personal Information, or the APPI, includes a proposal for processing personal data for AI development without consent. Meanwhile, Australia has taken a completely different approach. Last year in October, the Office of Australian Information Commissioner released guidance explaining how the Privacy Act and the Australian privacy principles apply in the AI context without making any changes to fundamental legal basis for processing. This divergence highlights a broader regional trend. Some jurisdictions are carving out AI-specific exemptions in the data protection laws, while others are choosing to work within the existing frameworks. So where does it leave us? Consent is a cornerstone of data protection APAC, but we are clearly seeing a shift, a move towards a more nuanced and flexible framework, one that recognizes both the power and limits of consent. We put together this report to help you navigate that shift. Whether you're managing compliance, updating policies, or advising on strategy, we hope this issue brief is something you will come back to. And if you ever feel like you can't keep up, sign up for FPF membership. That's what we're here for. With that, I'm really excited for the panel discussion ahead, featuring our fantastic panelists, Charmian and Darren, who will take us deeper into what all of this means in practice. Thank you again, and I will now hand the time back to Josh to lead us into the discussion.
Thank you very much, Sakshi, for giving that great summary of the issue brief. As you can tell, that there has been a lot of changes, right, in jurisdictions like India, like Vietnam, Indonesia, Malaysia, South Korea, Australia, just to name a few. And of course, this whole wave of AI coming in has also been shaping how regulators are approaching the issue of consent and legal basis. So thank you very much, Sakshi, for that, and also for being one of the key authors of the report. So now let's turn to the next segment of this call, which I'm personally very excited for, because as I said, we'll be inviting on board two excellent speakers whom I'm very grateful to be able to call friends in this space, to share their thoughts on some of the things we discussed in the issue brief. So let's welcome aboard Charmian Aw and Darren Chng. Hello, both. So
Hi, everyone. Really good to be here.
wonderful. Thank you. Great to have you guys, and thanks for joining us. Let me first do the needful and introduce the both of our speakers. They both have excellent backgrounds, so do give me some time to get through them. So let's start first, of course, with Charmian Aw. Charmian is a partner for global regulatory work at Hogan Lovells. She is a leading practitioner in data privacy and cybersecurity in the APAC region, with extensive technology, regulatory, and transactional experience. For more than 18 years, Charmian has built a track record representing market-leading global corporations in navigating the increasingly complex, diverse, and fast-evolving tech and data legal landscape in the Asia-Pacific region. Now, turning to Darren Grayson Chng is a senior fellow for FPF Global. He is also, in his main role, the regional data protection director at Electrolux, where he leads privacy and related AI compliance across the Asia Pacific, Middle East, and Africa, while co-developing group-wide privacy and AI governance policies and processes. So I like to joke that Darren basically never sleeps. Darren currently also serves as an expert for the OECD on data-free flow with trust. So without further ado, please join me in welcoming our speakers. And during the conversation, as I said, please feel free to add your questions on LinkedIn and we will be picking them up. So let's kick this off, right, by first asking both our speakers this question. So, Charmian and Darren, since FPF's report on consent and other legal basis for processing personal data in APAC was first released in November 2022, we've seen all these jurisdictions introduce either new comprehensive data protection laws or amend and update their existing data protection laws. How do you see, for our audience, the landscape for legal basis for processing as having changed in this last 2.5 years?
Maybe I can start if that's okay, Darren. And firstly, just to say thank you to Josh and everyone at FPF for this opportunity to speak about something so timely and topical, which is consent, in the processing of personal data in the time of AI for APAC, right? So, I think I would summarize what we're going through with APAC as a journey. We are going through a journey, and at the moment, I would say we are at the takeoff stage. So things are only getting started. But prior to the takeoff, when we were taxiing across, I think for some time, I would say there were a couple of milestones. The first being, I think, back in 2018 when the GDPR was passed. And APAC was already looking at data privacy, but many were at a nascent stage, right? And so what we saw was a very consent-first region. If you saw some of the initial iterations of laws, including Singapore's, but also Malaysia's, the Philippines, you would see a very heavy emphasis on consent as the primary legal basis for processing personal data. No surprises that there were iterations, thereafter, right, where we actually introduced new lawful bases thereafter. But that's the first milestone. And then I would fast forward, I think more pointedly to your question, Josh. 2.5 years, I mean, I still have PTSD, but there was the pandemic, right? We had another milestone, which was COVID-19. And what that did, right, what the pandemic did was a couple of things. One, I think we saw an acceleration of digitalization. And so, the whole, I think it gave a boost to the whole conversation around privacy and digital regulation for many parts of the world, including APAC. The second ripple effect from the pandemic, I would say, was to cast a spotlight on other lawful bases. For example, and I remember this very distinctly, we had regulators come out to, issue advisories and guidance around how do you use personal data for contact tracing, for vaccine administration, right? So we had things like the whole public health, medical emergency discussion basically thrown into the spotlight much quicker than it would have been, but for the pandemic. And I think that those two milestones have now led to the third milestone, which we are actually now experiencing, which is the surge in generative AI or AI more broadly, where I think it's put some, I think, pressure on traditional concepts of consent. And so on that journey, we are looking for the right level of calibration around all of these legal bases. So I'm going to pause there and turn it over to Darren.
Thanks, Charmian. First, let me quickly thank Josh and FPF for inviting me to speak on this LinkedIn Live, and to thank everyone tuning in right now, whether it's you're doing it on Thursday morning during working hours or doing it on Wednesday night in the US or other parts of the world. Thank you for tuning in. When we talk about change in the legal basis for processing, I'm thinking about a before and after comparison. So in terms of regulation, over the past 2 to 3 years, many APAC countries have been evolving. Some enacted standalone privacy laws for the first time, like China, Indonesia, Vietnam, India. Some amended their privacy laws, like Singapore, Australia, Malaysia. And out of the APAC countries, I think the clearest change occurred in Singapore. The 2020 amendments to its Data Protection Act, Personal Data Protection Act, added 2 exceptions to having to collect consent. One is legitimate interest, 2 is business improvement. And then 2 existing exceptions to consent were also expanded: the research exception and the business asset transaction exception. And the Singapore government said that this was to support data use for innovation. So I think it's an obvious change to providing more legal bases for processing, or I prefer to call it a wider selection of tools in the toolbox for companies to use. And then when we look at, for example, Malaysia and Australia, their amendments in comparison haven't changed the number of scope of legal bases. Vietnam has a draft personal data protection law that's probably going to be passed this year. I see no changes to the number of legal bases between that and the existing Decree 13. And then when you look at countries that have enacted laws for the first time, all of them have legal bases for processing in addition to consent. So in every country now, you have a selection of tools for companies to use.
All right. Thank you so much, Darren. I think that's really, really helpful. I also did want to add, you mentioned good morning in the APAC region. Well, let's not forget our friends from Australia as well. I think it's good afternoon for them. So good day to everyone. But I mean, Charmian, turning to you, right? I think what I took away from your sharing was the through line that you drew from 2018 all the way till now. And I thank you for sharing that context as well during the COVID-19 pandemic years with the rise of digitalization and how we are still kind of seeing the after effects, if you will, of that period of time. So I want to turn a bit now, just specifically more to the issue of consent, right? In the 2022 report that FPF released, we recognize that while consent is an important legal basis and remains so, there were also potential challenges in over-relying on consent. So, for example, there are differences in what's considered valid consent between different jurisdictions and countries. There is the issue of consent fatigue that's faced by data subjects, and also complications around the development and deployment of new technologies. So looking at the new and the amended data protection laws that's come up over the last 2.5 years, how do you think jurisdictions across APAC have managed these considerations or taken them into account?
I think that there has been a general consensus that consent may not be sufficient, right? So when we're talking about, I think, the constraints of consent, I like to think of them in three buckets. The first would be the whole aspect of scalability, right? So, and bearing in mind, like this is the numbers game discussion. When you think about APAC in particular, we house 3 of the 4 most populous nations in the world. So when you're talking about obtaining consent from your data subjects, your customers, your employees, that might be very challenging. So scalability is always a challenge. And the second bucket would be what I like to use, as a metaphor or an analogy, the square peg round hole situation. So what do I mean by that? I think this is where consent is simply not fit for purpose. So firstly, I mean, we all can agree that consent is highly contextual, right? So in some contexts, right, I talked about the pandemic, it's just not feasible to get consent. We also think about data transfers, which I actually personally feel consent is that square peg round hole situation, because when you're talking about, the fundamental premise of what it is to, put in place a cross-border data transfer requirement, it means, you should still hold some level of responsibility to protect that personal data, even though it leaves the borders or the territorial boundaries of the onshore premise or the onshore jurisdiction that you are based in, right? So you can't just outsource it. Like the minute it goes, somewhere else, it's like, oh, it's no longer my problem. And so putting the onus on data subjects, right, to give the requisite consent so that it cures your so-called, protection obligation in a cross-border situation may not be the right, it may not be the best mechanism, I think. And individuals are just not, as well informed on the adequacy or sufficiency of data protection laws. I mean, if you're asking the man on the street, you can't expect him to. And I think we also see this situation play out actually in for example, cookies, right? I mean, I don't think the original intention of consent was bad. Like there is a very good genesis for having consent, right? I mean, we know the OECD principles, but it actually doesn't refer to consent. It talks about individual participation, it talks about purpose specification, collection limitation, and all of that point towards the need to respect an individual's freedom of choice, the ability to participate or to have some say in how their personal data is being processed. Having said that, I think we have gone further down the road where we've tied our knickers in a twist, to use some lingo, casual lingo there, where the legalistic requirements have kind of taken over, right? Which leads me to my third bucket of the constraint of consent, which is the cart before the horse, meaning that the requirements have become so overly legalistic, so overly technical in certain instances that we no longer really remember why we're actually seeking consent in the first place. And I'll give you some examples, right? I mean, laws actually cite consent requirements as being, this is where you get valid consent only if it's unequivocal, clear, unambiguous, active, explicit, specific, well-informed. I mean, all of this, frankly, becomes a little bit of legal jargon when you translate it into, say, a privacy policy or a consent form. I remember, pre sort of GDPR and, all of this stuff happening, you would, for example, go to a dental clinic or even, say a hospital, and you would, take a queue number and you would see the doctor, right? Easy. Nowadays, you have to be in queue, you have to sign a bunch of forms. Half of it is data privacy related. And I think it becomes very unwieldy, right? From the consumer standpoint, it's like, do we really understand what we're ticking the box for? When we, and when we click on a cookie banner and just say, essential only, do we really understand, right, the what got us here? So I think we might have maybe gone too far down the line, and maybe the scale has tipped one side too much. But those are just my thoughts around kind of like why consent has its constraints.
Thank you, Charmian. So I like the visual imagery that you painted in terms of scalability, square peg, round hole, and cart before the horse. And I think these points are certainly very, very pertinent. I think jurisdictions, as we can see across APAC, have indeed started to take them into account. I think turning to Darren's point about how Singapore, for example, as a jurisdiction, has tried to put in the hands of regulators and for industry companies more tools in the toolbox, as he said, right? For compliance or for enforcement. So Darren, I wanted to turn from you, right? You come from a company, you're within the company. So wanted to ask you from a compliance perspective, how has the landscape in APAC changed for you? Do you think companies operating in APAC may still be leaning towards consent as the go-to legal basis because it is simply more easy to implement, more straightforward to implement, at least on the surface, as Charmian has alluded to? Or are they increasingly rely on other legal bases that are being provided as well?
Thanks, Josh. First, maybe let me say that there are regulators that are clearly cognizant of the consent fatigue issue, and Philippines and Singapore are the most obvious cases to me. For example, Philippines has this 2023 guidelines on consent, which highlights consent fatigue and encourages controllers to think about whether there's some other lawful basis apart from consent that can be used. For Singapore, there's a lot of guidance materials issued by Singapore's regulator on legal bases, with the latest one being the advisory guidelines on the use of personal data and AI recommendation and decision systems, which gives examples on the use of the exceptions to consent in AI system development, testing, and monitoring. But when it comes to companies and on-the-ground realities, overall, I think companies are still heavily reliant on consent because it remains the common denominator across many jurisdictions. That said, there is some opportunity for relying on other legal bases, and I'll get to that. So practically, whether companies can use consent or not can depend on a few factors. For example, are they already using consent? And if so, companies usually don't want to change something that's not broken because we have limited resources. Compliance is endless. I mean, is any DPO listening in happy with your current data inventory? Companies are going to be focusing on their resources on the biggest risks. So changing something that's not broken is going to be lower priority. And then number two, it needs to be painful enough. And I'm not suggesting that you listeners do this. So an example is if of maybe painful enough is if 1,000, 10,000, 100,000 customers withdraw consent, right? In such a case, it might no longer make sense for companies to rely on consent, and they have to look at some other legal bases. And then coming to the best opportunity, I think, to get companies to consider other legal bases is when they want to process personal data for a new purpose. There, they have to think about, okay, do I want to go bug my customers to provide consent? If I think lots of them aren't going to read my request for consent, let alone give consent, then what other legal bases can I rely upon to get that consent? And actually, even in this case, right, there are countervailing considerations like what are the conditions for using the alternative legal basis? Is it going to be more tedious to rely on consent? Is doing a data impact protection assessment going to be more tedious than using my existing structures, processes for getting consent? And then if I want to do this new thing in a few countries, what legal bases are present in all these countries with similar conditions such that I can use the same thing in all these countries? can I scale
Mm.
up? So, for example, if 5 countries recognize legitimate interests as a legal basis and 5 don't, then legitimate interests may be a tough sell to companies. But if 9 out of 10 countries recognize legitimate interests, they have similar conditions for using it, which is to do a data protection impact assessment, then yeah, maybe you can use it. Um, so at the end of the day, even if companies are relying on some other legal basis, I think they still see consent as a good safety net. And where they are not limited to selecting just one legal basis to rely on, I know of companies that still collect consent for that safety net.
Thank you so much, Darren. I think that's really, really helpful. I think the main thing that came out from what you shared, at least for me, is for jurisdictions to also keep in mind, especially regulators and policymakers, to keep in mind what is the ease of being able to enable their companies to tap on the data pools and data resources that they have. And one part of that calculation has to be also looking at what is the most, I guess, common denominator among the various jurisdictions, because that is something that companies will definitely be looking at. So, Charmian, I did want to pick up on one comment that was raised in the comments on LinkedIn, and at the same time, kind of fold it into a question that we've been chatting about as well. So there's still a number of evolving developments in the region. So, for example, there's the ongoing review of the Japanese APTI, their data protection law. The implementation of new data protection laws in India and Indonesia, expected new laws in Vietnam, and potentially, as Nicole says, fingers crossed for the tranche 2 privacy reforms in Australia moving forward. So looking forward, right, what do you think are the trends for legal basis going to be in the region? And what suggestions or recommendations would you have for industry or governments when it comes to looking at legal basis?
I think it's a multi-party discussion that we need to have. So hopefully, in refining and fine-tuning, the laws in APAC, the regulators, the policymakers are engaging with industry and the wider public around something as critical as legal bases, because you have stakeholders that are your data subjects, you have stakeholders that are the businesses that are having to comply with the obligations, and I think everybody has a right and should have an opportunity to be heard before really finding the right balance, right, for the individual markets. Because we also have to remember that, and worth reminding everyone that, especially people who don't live in this region, that APAC is extremely vast. We're talking about diverse cultures, nuances that are very important, geo-economic, geopolitical type climates, right? In all these, and the population disparity amongst, the largest, market in APAC versus the smallest is gigantic. Is absolutely enormous. So, I don't think we can think of it in a very monolithic way. Having said that, I do think that engagement across all the different stakeholders and ensuring we get there will be crucial. And there's also it's useful to be slightly later on in the game, right? So I talked about digital regulatory nascency, as in we are not as digitally mature, I would say, in terms of regulation compared to, say, the EU. But there are pros to that, because we can take lessons from the EU, right? I mean, they have an ongoing kind of discussion around, how do you use legitimate interest in a number of settings, and we almost can take lessons from their experience, right, their journey, and I think but I think I remain cautiously optimistic that actually there will be more alignment and consensus and even convergence on the underlying principles around legal basis, and that we will see more commonsensical, like policy thinking around when do we actually deploy, or when do we actually introduce, or when do we start amending laws to introduce, right, sensible legal bases, because there is a need. Yeah, so that's my kind of high level optimism around that question.
Yes, thank you so much, Charmian. I think, your last point about making sure that jurisdictions look at things sensibly, make sure that they keep up to date with the developments and not just simply let things go by, but at the same time, keeping a watch of developments and finding the right time to jump into things and trying to work towards some sort of regional or even global consensus brings to mind a phrase that I heard of recently. And I'm going to paraphrase it. I don't think I can remember the exact words, but it goes along something like this. There is no time to waste, but at the same time, let's not make too much haste. Right. So there is no time to waste in terms of keeping up to date with developments, always learning what the new technologies are coming up, how business trends and the regulatory environment is evolving around the region. But at the same time, don't have knee-jerk reactions, right, towards new technologies that are coming up. Oh, this immediately something that we must jump onto it without considering the fuller picture, the bigger picture. So I think that's really, it stood out to me. Darren, I wanted to ask you, right, anything to add to Charmian's observation? So the point that you had mentioned in the last comment that you made was that if, for example, if there are only 5 jurisdictions doing legitimate interest, companies may say, okay, let me wait and see a little bit longer. But if it is 8 or 9 jurisdictions, then companies will say, okay, actually, I think it's something worth looking into. What do you think jurisdictions can do to kind of build that consensus a bit better? What mechanisms are there to kind of collaborate and share information? So, Darren, any thoughts?
Um, Difficult question. For regulators, offering different legal bases for companies to use, offering different tools for selection is definitely very helpful. My respectful comments are that it's not just about the act of offering different tools. It's not just the existence of different tools, but it also boils down to whether the same tools are offered across the world and the conditions for using these tools. The more similar they are in different jurisdictions, the easier it will be for companies, especially those operating in various jurisdictions, to adopt them. And I'm not saying we need to give up regulation, give up protecting personal data, but I think we need to move towards simplifying things than going down to a very granular and prescriptive level, because it just makes it so much harder for companies to comply. And then for companies, I feel you, and I think my compliance tips to companies are going to be broadly the same as before. Think about your risks, consider your resources, and take a look at the material put out by FPF, because I think a lot of it is very helpful for staying up to date and helping you figure out what you need to do, what processes you need to put in place. Third thing is prioritize. And then lastly, pace yourselves, because compliance is never ending.
Thanks so much, Darren, and thank you, of course, for that shout out as well. Really appreciate it. I mean, if I may, right, I just want to turn to you, Darren, just to follow up on that, and also Charmian as well, to have if you have any thoughts. I know we are coming up on time. I think about eight minutes soon, like, so that I think this might take us maybe to one more question afterwards, and then we can start to close. So, Darren, you mentioned some I guess a positive outlook or mindset that companies can take when looking at the region. But do you have any more specific compliance strategies or tips that you have for fellow in-house privacy practitioners in managing their APAC compliance programs? Charmian, same to you as well. I'm sure you have many companies going to you to ask for thoughts and advice. What sort of thoughts and advice would you share with them? So, Darren, maybe we start with you.
Specifically, there are so many things we need to deal with every day. I mean, even in terms of legal basis, I mentioned that companies, I think companies are mainly going to rely on consent still. They're not going to change what's not broken. So it's when you come to the case where you have to think of whether you want to use consent or not. I mean, there are a lot of factors involved. It depends on the state of technology your company. For example, if you have automated systems to handle consent, to manage consent, to handle data subject requests, withdrawal of consent. If you don't have such systems in place, don't really have processes, then yeah, I think do try and consider relying on other legal bases. But if your systems are in place, I mean, actually, consent withdrawal and handling consent is probably not going to be such a painful issue for you, because you don't have to deal with it manually. So it really depends on what you as a company have in place, what resources you have, technology you have to manage this.
Thanks,
Yeah,
Darren. So, Charmian, over to you. Any thoughts?
Yeah, I was smiling when you asked that question, Josh, because it reminded me of one of the most common questions I got asked, and still even to today get asked sometimes for APAC, which is, we have already done GDPR compliance, right? Could you just help us do a quick APAC review to make sure that we're okay for APAC? And it's like, all right, you do realize APAC is this vast and this diverse and the X number of laws, but actually, without kind of being too kind of offended by that sort of question, actually it's a smart strategy to take forward, because what you're doing is problem solving, right? You are dealing with different compliance requirements across the globe. It actually makes sense to start with somewhere where you have something a bit more uniform or harmonized with regards to the EU, and then working your way from there. But having said that, I always stress, right, to clients or to anybody that asks really, that with regards to APAC, it's definitely not a one size fits all, and we are seeing this more and more so, right? I mean, Sakshi did a fantastic job running us through the kind of areas where there are nuances, and these need to be respected and need to be operationalized. For example, with regards to consent specifically, remember that you're dealing with very, very different language requirements in APAC, right? Sometimes there is a local language requirement that will trickle down to whether your consent is even valid. There are formatting requirements. Sometimes it has to be in a printable format. There are things like around deemed consent. How do you prove that consent is deemed? So there are all these conditions that I think Darren spoke about as well, which need to be paid attention to.
Thank you so much, Charmian and Darren. I think we have time for just one more question. I actually have two questions on the list, but I think what we can do is that for the spare question, if Charmian or Darren don't mind, we can always answer them offline, right? Because they will continue to live on LinkedIn, although not on LinkedIn Live. Haha. Okay. I think one question that did come to mind was, we've spoken about regulators and governments. We've also spoken about companies. I don't think we've spent that much time yet talking about individuals. And there was a question that I want to ask you quickly, just for your quick thoughts, right? Which is, the average person becomes interested in the legalities of data protection only after being notified of data breaches. Is that true or is that false? What are your thoughts? Quick fire round.
I'm going to go with I'm not going to say neither, but it's both true and false depending on the situation. I think, before, so when, remember when Singapore started, we started having the PDPA, right, 2012, and then it came to full force 2014. I remember there was already this kind of like public awareness building around things like privacy. And I think actually the average person, at least in Singapore, started becoming interested. They started asking things around like, hey, do I really want to give my mobile number, or do I need to give my NRIC number in full? And so it was a process, right? Like it was a build up. And I think we're now at a stage where people actually do have a good handle of what the PDPA is about and what rights they have around the processing of their personal data, right? So it's not a situation where only if a breach happens then they start getting interested. Having said that, I do think that a data breach sometimes propels the conversation forward around data privacy, because back to my point about scalability, when you're talking about a breach, you're talking about not just about one data subject being interested about how their data is being processed by company XYZ, but it's scale. It's literally an entire sort of a pool of data subjects that could be impacted by an incident. So I think it's a great question. I think it's not necessarily binary, true or false. It's probably a bit of both.
All right. Thank you, Charmian. Darren, quick one.
It's I think it can be country dependent. Because I agree with Charmian that people in Singapore are quite aware of personal data protection, what the law says, what the law requires, and that is largely due to a lot of educational effort on the part of Singapore's regulator. And then if you compare it to another country where the law is very new or there's no law at all, people probably aren't even going to be interested in legalities of data breaches because there's no law, or they are not familiar with the law at all. They are not aware of what harm can come to them from data breaches. So I think it's dependent on the country itself, and we have to go down one layer more than just the average person across the world.
If I had to buy a coffee for every time I ask a question and Darren has a pained look on his face, I need to buy him a lot of coffee. But on that note, Charmian and Darren, thank you so much for your wonderful responses. And to our audience that's been so engaged and so keeping up with the conversation, thank you for joining us at today's launch on LinkedIn Live. I think we have to conclude the conversation here, but please join me in thanking our wonderful speakers for today, Sakshi, Charmian, and Darren, for gamely taking on this fun format and delivering excellent insights in the process. I want to also thank the team in the background, which has been working hard to make this LinkedIn Live launch possible. And once again, FPF APAC and FPF as a whole is always grateful for your continued support, partnership, and friendship. And we look forward to seeing you again soon. Have a great rest of the day ahead and take care. See you somewhere in the world. Bye-bye.
Thanks, everyone. Thank you.
Thanks so much,
everyone.
Charmian. Thanks, Darren. Thanks, guys. Bye-bye.